So by now, everybody's already aware that the DA's office in Fulton County withdrew their petition to violate YAC's probation. Let's talk about what should have happened, what I believe is going to happen, and what would have happened had he been in Florida. YAC is pending 2 substantive cases outside of his probation violation. He has a introduction of contraband case, and he has an aggravated battery case. Those are unrelated to his probation case. The only way they're connected is that those cases are being used to violate his probation. He's in front of apparently 3 separate judges, Judge McBurney, Judge Whitaker, and Judge Leffridge, I believe. I really don't understand why. He should be in front of the same judge. Being in front of the same judge would have made this so much more efficient. Had he been in Florida, I believe he would have been in front of the same judge, at least in South Florida. So now that there is no probation violation pending, what does that actually mean? He is charged with 2 charges that have bonds. They are bondable offenses, right? If we recall, Judge McBurney didn't exactly give him a bond. He kind of just held off on whether or not he was going to do so. Had he been in Florida, specifically had he been in Miami or in Broward, he would have been arrested on the probation violation. He was already in custody, but arrested. And then he would have gone before the judge that his probation case is in front of. That judge would have probably denied him bond, but he would have seen the bond judge on the substantive cases that would have given him a bond. So what would have happened when the probation violation was withdrawn is there would be no more probation violation, and he would just be able to bond out based on the bonds that already exist. So I'm not exactly sure why that doesn't happen in Georgia. Any Georgia lawyers, please drop down in the comments and let me know. But procedurally, logistically, legally, that is what makes the most sense to me. But for some reason, it just didn't go that way. So that's how it would have happened in Florida. Now, in Georgia or in Florida, the concept is still the same. He is not pending a probation violation right now. And I don't believe that Judge McBurney, who was handling his bond hearing, has any reason to or will keep him in custody. So what we are hopeful and hoping is that he'll go back before Judge McBurney. He'll be granted a bond on the 2 substantive cases, and then he'll be able to bond out. Once he bonds out, he has to deal with the same process that he dealt with the YSL case, which is now there are 2 pending cases, and he's preparing for them, for trial or whatnot, but he's preparing for them from the outside of the jail. So that is what I expect to happen, that he's going to go before Judge McBurney and be granted a bond and be able to bond out. I have my fingers crossed. Legally, that is what should happen. Quite frankly, no real reason to not grant him a bond. Again, the YSL case is done and over. None of those charges, none of those allegations, I don't believe are legitimate basis to make any arguments as to why he should stay in custody. And I think the Fulton County DA's office, they understood that, and that's why they pursued this probation violation in the way they did, because quite frankly, if they didn't have that card to play, he would have been out probably the same day as his trial was over. So there's that. I'm paying attention. I'm following what's going on. So as soon as I get more updates, I will give them to y'all.